Sarah, do you want to make a brief introduction on behalf of OUP, and then we'll get going?
Hello, so I'm Sarah Harris, the Managing Editor of the Journal of IP Law and Practice, and I'm very proud to welcome you to our 6th webinar today. Stefano will be joined by 2 expert speakers to discuss US patent law. We'll also share a copy of the accompanying article in the chat box. Thank you, Stefano, and our speakers for sharing your time and insights today. We really appreciate it. Thank you. Stefano.
Thank you, Sarah. Thank you, Sarah. So I assume that probably many of you who are participating today are already familiar with this series of webinars, but they come from a series of roundups that the Journal of Intellectual Property Law and Practice has published in the past month or so, concerning essentially 2019 decisions across all the fields of IP from various jurisdictions. And in terms of patent law, we've had roundups concerning the UK, China, Germany, and the US. And this is our last webinar where we will look at essentially developments in 2019 in US patent law. As Sarah said, I will share the accompanying article right in the chat in a moment, and I will also share the slides that the speakers have prepared for all of us today with just some pointers to the cases that are going to be mentioned. So without further ado, let me introduce this fantastic speakers today. We have first on my Zoom list, David Bassett is joining us from New York. David is a partner at WilmerHale with vast experience across all the fields of IP, and I think a particular interest in biotech and pharmaceuticals more than the other fields. So David is the author of the roundup that the journal has published, and so I wish to thank him so much, not just for being here today, but also for all the time and the effort in writing a very, very interesting review of the cases in US patent law in 2019. Next to Dave, we have Shirley Cantin, who is a senior counsel in IP at Gilead, and I believe formerly part of WilmerHale as well. Right, so Dave and Shirley will guide us through all the relevant cases from 2019 and a bit of an overview of what we have to expect for the future. Before I let Dave and Shirley start, let me share some technical information. As I said, I will share the slides and the article in the chat in a moment. I will also share a link for those of you who are not able to access the files from the chat itself. We kindly ask all the participants to keep your microphones and cameras switched off if possible, because we're going to record a webinar and we will then make it available on YouTube as well. And finally, for any questions, any IT issues that you might have, or questions for Dave and Shirley, if you can share those in the chat, I will keep an eye on the chat and assist you with any sort of issues. And also, if there's any question and there's time for Dave and Shirley to answer, I will direct them to them at the end of their presentation. Okay, so thank you very much. And Dave and Shirley, all yours.
Great, thank you. Well, Shirley, did you want to start or?
Yeah, so Dave, thanks for having me. And I was just curious, how does one go about identifying what is called the top US patent cases in any given year?
Well, of course, it's fair to say the choice is somewhat subjective, but based on my experience in US patent litigation for over 30 years, try to identify those cases that I think will have the greatest impact going forward. I also confirmed the choices and selections I made by looking at other year-end roundups after 2019 to make sure I wasn't missing any key cases. The US Supreme Court only decides a handful of patent cases each year. Last year, it only decided 2. So US Supreme Court patent cases by default go on the list. The Federal Circuit, by contrast, which has nationwide exclusive appellate jurisdiction in patent cases in the United States, last year had nearly 300 patent cases appealed to it. So try to look at trends to identify the most important trends going forward so that we can talk about those cases. And I'll just note that we've put the complete citations for each of the cases that we will be discussing in the slides. So you should have, each of you should have those citations if you need them.
So then what were the most important trends among the top US patent cases in 2019?
I think it's fair to say that with the exception of one Supreme Court case, which we'll discuss separately, The most important U.S. patent cases in 2019 primarily related to two widely divergent topics. First, the precise parameters of three new types of post-issuance administrative procedures that were created by the America Invents Act back in 2011. And then secondly, the ongoing debate about the precise and specific scope of patentable subject matter in the wake of two U.S. Supreme Court cases addressing the scope of 35 U.S.C. Section 101.
All right, so let's discuss those two topics separately, starting with cases addressing the parameters of the post-issuance administrative procedures. And for those of us that might not be familiar with them, what do you mean by these new administrative procedures created by the America Invents Act, or what we call the AIA?
Right. Well, in 2011, the U.S. Congress enacted the Leahy-Smith America Invents Act, and as you said, it's often referred to as the AIA. Among other things, the AIA created a new entity called the Patent Trial and Appeal Board, which is often just called the board. And the AIA established three new types of administrative review proceedings before the board, establishing that a person other than the patent owner can challenge the validity of any patent post-issuance. Those three different types of proceedings that were created were known as inter partes review, or IPR, post-grant review, or PGR, and then covered business method review, or CBM review. Each is slightly different, but for our purposes today, it's enough to note that a number of the key cases from 2019 address the various aspects of those administrative review proceedings before the board.
And I think one ruling in particular caught a lot of us in the patent litigation bar by surprise. Certainly I did when that came out. Do you want to talk about that case?
Sure, indeed. On October 31st, 2019, in the Arthrex versus Smith and Nephew case, a panel of the Federal Circuit found that the appointment of the board's administrative patent judges, or APJs, by the Secretary of Commerce violated the Appointments Clause of the U.S. Constitution.
And before turning to the merits of that opinion and its implications, maybe it'd be helpful to provide some background context on the fact pattern in that case.
Sure. Arthrex owned a patent directed to a knotless suture assembly. Smith and Nephew filed a petition requesting an IPR review of certain claims of that patent. The board instituted the review, and the IPR was heard by a panel consisting of 3 APJs. After briefing and hearing, the board issued a final written decision finding the patent claims unpatentable as anticipated, and Arthrex appealed to the Federal Circuit.
And then what happened at the Federal Circuit?
Well, first, the court had to address the threshold question of whether Arthrex had waived its constitutional argument because it had not made that argument to the board. The court ultimately found that Arthrex had not waived the argument, primarily because I think the board or the court just thought it was an important issue. They said it's of exceptional importance, and they said, therefore, they are going to overlook the waiver and address the issue on the merits.
And what did the Federal Circuit conclude?
Well, Arthrex asserted that the APJs who presided over the IPR addressing its patent were not constitutionally appointed pursuant to Article 2, Section 2 of the U.S. Constitution. More specifically, it argued that the APJs were what are called principal officers, who must be, but were not, appointed by the president with the advice and consent of the Senate, as opposed to so-called inferior officers who can be appointed by heads of departments without the advice and consent of the Senate.
And what did the Federal Circuit say regarding Arthrex's argument?
Well, surprisingly to many of us, the Federal Circuit agreed with Arthrex. It first concluded that the APJs are officers of the United States, as that term is used in the U.S. Constitution, particularly given the significant discretion that the APJs have in the IPRs over which they institute. The court then turned to a detailed analysis of whether the APJs are principal officers or inferior officers, focusing on three primary factors. First, whether the appointed official has the power to review and reverse the APJ's decisions. Secondly, the level of supervision that the appointed official has over the APJs. And finally, whether the appointed official can remove the APJs. Having considered all of those issues, the court concluded that the APJs are principal officers under the U.S. Constitution.
So after coming to that conclusion, then what was the remedy that the court deemed appropriate in these circumstances?
Well, having determined that the current structure of the board was unconstitutional, the board next turned to the question of severability. That is, it looked for what's the narrowest remedy that the court believed could fix this constitutional violation. It then concluded that the appropriate remedy would be to strike the statutory provisions that limit the removal of the APJs. Therefore, pursuant to Arthrex, unless something changes, the APJs can be removed by the director of the U.S. Patent and Trademark Office without cause.
So what's happened with this Arthrex case after this surprising ruling?
Well, it's fair to say that none of the parties in the Arthrex case were very happy with the ruling. On December 16th, all of the parties in the case petitioned the Federal Circuit for rehearing or rehearing en banc. All of those petitions were denied on April 2nd, 2020, and most expect the parties to seek cert from the Supreme Court. However, the Federal Circuit has since denied a request to stay the mandate in the Arthrex decision while Arthrex appeals to the Supreme Court, saying that putting its decision on hold could harm patent licensees by leaving in force patent claims that wouldn't otherwise be valid if the decision remained in effect.
So what's been the impact of this case on other cases in the meantime while this continues to play out?
Well, on May 4th, 2020, the PTAB made the understandable decision to halt proceedings in over 100 cases that had been remanded to it under the Arthrex ruling until the Supreme Court weighs in. So in those cases, the parties are going to be in a holding pattern for perhaps up to another year. Then the next day, on May 5th, 2020, the PTAB made the precedential ruling that only patent owners can leverage Arthrex to get a new hearing, not patent challengers. The PTAB reasoned that while patent owners whose patents were invalidated could bring an Arthrex challenge to get their cases reheard in the PTAB, the same remedy should not be available to petitioners because, according to the court, they knew or should have known about the structural deficiency and only chose to dispute the board's constitutional authority after receiving an unfavorable ruling. So stay tuned. The same ruling, there's going to be a ruling most likely either from the Supreme Court or the Federal Circuit related to this issue in 2020, and that case will likely be one of the top cases from 2020.
So we'll stay tuned for the 2020 rendition. So in contrast to the Arthrex opinion, the Federal Circuit also issued another ruling in 2019 that wasn't particularly surprising. And that was after it had already determined in 2018 that IPR proceedings were not barred by this concept of tribal sovereign immunity. Can you tell us more about this ruling?
Yeah, that's correct. The case was the Regents of the University of Minnesota versus LSI. And in that case, the University of Minnesota is an arm of the state of Minnesota, and it's one of the largest public research institutions actually in the United States. Not surprisingly, the university often pursues patent protection on its various, that arise from its research. There were IPR petitions that were directed to certain University of Minnesota patents. The University of Minnesota filed a motion to dismiss those petitions based on state sovereign immunity. The U.S. Patent and Trademark Office convened an expanded panel of the board to hear this argument because it was so important and determined that state immunity did apply to IPR proceedings, but further determined that the University of Minnesota had waived its immunity in this particular case because it had also sued the petitioner for patent infringement in district court prior to bringing, prior to the IPR proceeding going forward.
Then how did the Federal Circuit address UMIN's assertion of state sovereignty immunity?
Well, the Federal Circuit started this analysis by noting that states typically enjoy immunity from lawsuits brought by private parties. That's part of the United States' weird history where the states were independent before signing the Constitution. So therefore, the states enjoy sovereignty that they possessed before signing on to the U.S. Constitution. But there's always been an exception to that. Suits brought by the United States against the states, there is no state immunity blocking such litigation. The Federal Circuit then noted that the Supreme Court had already determined that IPR proceedings are essentially just an agency reconsideration of the patent grant. Then based on its analysis of 3 different factors, the Supreme Court concluded that the fact that Congress enlists the help of certain individuals in the IPR proceedings does not change their essential characteristic. First, it is the director of the Patent Office, a politically appointed official in the executive branch who ultimately decides whether or not to proceed against the sovereign. That is, while any person can petition for an IPR, it is ultimately the director who makes the decision whether to institute the IPR, and it's in his sole discretion. And in fact, that issue or that decision is unappealable and unreviewable. Second, even if the petitioner or patent owner withdraw from the IPR process, it can go forward to a final written decision. And third, the IPRs are distinct from ordinary civil litigation in the United States. The federal rules of civil procedure do not apply, and even though there is some discovery and live hearing in IPRs, they're much more limited than in civil litigation. So ultimately, the court determined that any differences between state and tribal immunity did not warrant a departure from its earlier ruling that such immunity did not apply to IPR proceedings.
Great. I think we've mentioned a couple times on the webinar that any person who is not the owner of the patent can petition the PTAB to institute an IPR, but the Federal Circuit made clear in 2019 that to be able to appeal a board ruling to the Federal Circuit, a party needs to have what we call standing required by Article 3 of the U.S. Constitution. Is that right?
Yeah, it was in 2 separate opinions. The Federal Circuit came to that conclusion. First in the AVX Corporation case versus Presidio, and again in the General Electric versus United Technologies case.
If we can talk about 2 of those cases, that'd be helpful. So what was the background of that first AVX case?
Well, Presidio owned several patents, and AVX petitioned the PTAB for an IPR directed to those patents. In its final written decision, the board found that certain of the patent claims were unpatentable, but the AVX had failed to establish the unpatentability of all of the remaining claims. Presidio did not appeal, but AVX did appeal as to the upheld claims. Because the Federal Circuit determined that AVX lacked standing, however, it dismissed AVX's appeal without ever reaching the merits of the board's ruling.
So what was the basis for the board's determination that AVX lacked standing to appeal to the Federal Circuit?
The court first started its analysis by noting that because that the Constitution limits the grant of the judicial power to cases or controversies. So any party that appeals to the Federal Circuit, it said, must have standing before the court can consider the merits of the case. The Federal Circuit recognized that that could lead to an odd result, that an IPR petitioner who lost some or all of his challenges before the board might lack standing to appeal that adverse decision to the Federal Circuit.
What arguments did AVX make to support its standing to appeal?
Well, AVX made 2 primary arguments, but the Federal Circuit rejected both of them. AVX first argued that it was injured by the board's decision because of the statutory estoppel provision, which is set forth in 35 USC 315 subparagraph E. which would prevent it from asserting the same challenges if Presidio ever sued AVX for infringement of the patent. The court rejected that argument for two reasons. First, it says the estoppel provision is insufficient to confer standing where a party like AVX is not currently engaged in any activity that would give rise to a possible infringement suit. Secondly, the Federal Circuit said it had not yet decided the question that was the basis of this argument by AVX, whether estoppel would apply to a party who was unable to appeal that adverse ruling from the PTAB as a result of lack of standing. Second, AVX argued that it had injury in fact because it's sufficient to confer standing because the board's ruling had injured its ability to compete with Presidio. But the board concluded that that argument does not support standing, where AVX has no presence or non-speculative interest in engaging in any conduct that could arguably be covered by the patent claims at issue.
What happened in that second case you mentioned in the GE versus United Technology case, where the Federal Circuit also determined that to appeal a board ruling to the Federal Circuit, a party must still have the standing requirement that is set out in Article 3 of our Constitution?
Well, the GE had petitioned the PTAB for an IPR, but the board found that the claims were not obvious in view of the prior art. GE then appealed to the Federal Circuit. The court started its analysis by noting that GE has the burden of showing that it has suffered a sufficient injury to have standing to appeal. GE responded by submitting declarations from its chief IP counsel in support of its argument for standing, but the court found that, quote, GE's purported competitive injuries are too speculative to support constitutional standing. Without a real particularized injury, GE lacks standing to appeal the IPR decision, close quote. The Federal Circuit also rejected GE's economic losses argument. GE argued that it had been injured by increased research and development expenses that it was going to incur, that it had sustained by attempts to design engines that did not implicate the United Technologies patents. But the court concluded, quote, there is no evidence that GE is in the process of designing an engine covered by the asserted patent, nor has GE demonstrated that it has definite plans to use the claim features of the asserted patent in the airplane engine market, close quote. So while the Federal Circuit determined that the declarations submitted by GE in that case were inadequate, that opinion sets forth a pretty clear roadmap for the types of declarations that future parties could submit to establish standing to appeal.
All right. In addition to the Federal Circuit addressing who has standing to appeal these adverse board rulings in last year in 2019, the U.S. Supreme Court also addressed this question of who qualifies as a quote unquote person who can petition for AIA post-issue and review proceedings in the first place. Is that right?
Right. Yes. The case of return mail versus U.S. Postal Service in a 6-3 opinion authored by Justice Sotomayor, the Supreme Court addressed the question of whether a federal agency qualifies as a person who can seek such review and concluded it is not.
How did this case make its way all the way up to the Supreme Court?
Well, Return Mail owned a patent claiming a method for processing mail that is otherwise undeliverable. It asserted the patent against the U.S. Postal Service. I don't know who else they would have asserted it against, which in turn permitted the Patent Office, which in turn petitioned the Patent Office for CBM review. The board instituted review and found the subject matter of the patent ineligible to be patented. The Federal Circuit affirmed, holding the U.S. government is a person eligible to seek CBM review, and the Supreme Court granted Return Mail's petition for cert.
So how did the Supreme Court reach this conclusion that the USPS or the U.S. Postal Service is not a person who can seek AIA post-issuance review of a patent?
Well, the court began its analysis by noting that the patent statutes did not define a person in that term. And the court therefore said it should apply its longstanding interpretive presumption that a person does not include the sovereign and thus excludes federal agencies like the U.S. Postal Service. The court then rejected each of the three arguments that the U.S. Postal Service made in favor of displacing that presumption in this instance. First, it disagreed that anything in the AIA offered sufficient evidence that the government is to be considered a person for purposes of that statute. Second, it found unpersuasive the argument that federal agencies have a long history of participating in the patent process. It found that the process of these administrative rehearings are fundamentally different than the other processes that agencies have participated in the past. And third, and perhaps most surprisingly, it rejected the U.S. Postal Service's argument that the statute must permit it to petition the AIA for review because it is subject to liability for patent infringement. The Supreme Court just gave that argument the back of the hand, essentially. It said, quote, "We see no oddity in Congress affording non-governmental actors an expedient route that the government does not also enjoy for heading off potential patent suits," close quote, end of ruling.
So moving on to in another case, in a case addressing yet another aspect of AIA post-issuance review proceedings, in 2019, the Federal Circuit also expanded the definition of the parties who can be time barred from instituting an IPR, right?
Yes, yes. So Section 35 U.S.C. Section 315 governs the relationship between IPRs and further proceedings. And the relevant portion of Section 315B provides that an IPR may not be instituted if the petition is submitted more than 1 year after the date, quote, "on which the petitioner, real party in interest, or privy of the petitioner is served with a complaint alleging infringement of the patent," close quote. So in Power Integrations versus Semiconductor Components Industries, the Federal Circuit addressed what it said was an issue of first impression, whether privity and real party and interest relationships arising after the petition is filed, but before the petition is instituted, should be considered for purposes of the statutory bar. The Federal Circuit determined that such relationships should be considered.
What was the background of Power Integrations case?
Well, Power Integrations owned a patent relating to switched mode power supplies. It sued a company called Fairchild Semiconductors for infringement of that patent in 2009. Then in 2015, another company called ON Semiconductor, ON, entered into an agreement to merge with Fairchild. Before that merger closed, however, ON filed a petition for an IPR challenging certain claims in the Power Integrations patent. The Fairchild-ON merger closed several months later, and in fact, the board instituted the IPR 4 days after the merger closed. Power Integrations argued to the board that the IPR should be time barred under 35 U.S.C. Section 315B because ON and Fairchild were in privity at the time of the filing, and Fairchild had been served with an infringement litigation complaint more than 1 year before the petition was filed. The board rejected those arguments, finding the challenge claims unpatentable as obvious, and Power Integrations appealed to the Federal Circuit.
And how did the Federal Circuit address this issue of first impression raised by that appeal?
Well, ON argued that privity and real party and interest relationships for purposes of 315B time bar should be assessed only as of the filing of the petition, whereas Power Integrations argued that such relationships arising after the filing but before institution should also be considered. The Federal Circuit ultimately agreed that the best reading of the statute, as it put it, required consideration of privity and real party and interest relationships that arose after filing but before institution. But the court expressly noted that, quote, "we do not address the impact of a change in real party and interest privity, or ownership occurring after institution. So, close quote. So we should all be on the lookout for further rulings on that issue going forward, if not in 2020, then thereafter.
In 2019, there was also a SCOTUS or Supreme Court case addressing an aspect of the AIA that was not focused on the post-issuance review mechanisms, right?
Right. The Helsinn Healthcare versus Teva Pharmaceuticals case, a unanimous Supreme Court determined that the AIA did not change the law as to whether so-called secret sales can qualify as prior art.
And what was the background of the Helsinn case?
Well, Section 102A1 of the AIA precludes a person from obtaining a patent on an invention that was on sale before the effective filing date of the patent application. The relevant statutory provision precludes a patent if the, quote, claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention, close quote. Now, the patent statute that was in effect before passage of the AIA included similar proscriptions on, Section 102B, which was known as the on sale bar. But that statute did not include that language of or otherwise available to the public. That statute did not allow a patent to issue if the invention, quote, was patented or described in a patented publication in this or a foreign country or in public use or on sale in this country, close quote, more than 1 year before the filing of the patent application. The district court in Helsinn determined that unlike the prior on sale bar, the on sale provision of the AIA did not cover so-called secret sales, reasoning that the added phrase of or otherwise available to the public modified the term on sale such that an invention is not on sale for purposes of the statute unless the sale or offer in question made the claimed invention available to the public. The Federal Circuit reversed, and the Supreme Court granted cert to determine whether or not, under the AIA, an inventor's sale of an invention to a third party who is obligated to keep the invention confidential qualifies as prior art for determining the patentability of the invention.
And what happened at the Supreme Court?
Well, a unanimous Supreme Court determined that such a sale can qualify as prior art and gave really short shrift to Helsinn's arguments to the contrary. The court noted that every patent statute since 1836 had included an on-sale bar, and that precedent from both the Supreme Court and the Federal Circuit had long held that secret sales can invalidate a patent. The court concluded that in light of that settled pre-AIA precedent, the court presumed that when Congress reenacted essentially the same language in the AIA, it adopted that earlier judicial construction of that phrase. The court was not moved at all by the addition of the phrase or otherwise available to the public. It called that little more than a broad catch-all phrase, I think is how it termed it, that cannot be read as upsetting that long body of precedent setting forth the well-settled meaning of on sale.
All right, shifting gears a little bit, separate from the AIA and all the cases addressing the post-issuance administrative procedures under the AIA, the other topic that was addressed by the most important U.S. patent cases in 2019 related to the scope of patentable subject matter. Section 101, as folks know of the patent statute, provides that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent therefore, subject to the conditions and requirements of this title. These are the Section 101 cases. That seems like very expansive and broad language, Dave.
Well, indeed. And the Supreme Court famously referred to Section 101 and its legislative history as indicating that Congress intended there to be statutory subject matter for patents to, quote, include anything under the sun that is made by man, close quote. So given that kind of broad language, as you might imagine, for many years, subject matter eligibility played essentially no role in U.S. patent law.
So what changed?
Well, in a pair of decisions in 2012 and 2014, the Supreme Court articulated a more rigorous test for subject matter eligibility. First, in the 2012 case of Mayo Collaborative Services versus Prometheus, and then in 2014, in Alice Corp versus CLS. In sum, under the law set forth by the Supreme Court in Mayo and Alice, Section 101, while broad, notably contains an important implicit exception. Quote, laws of nature, natural phenomena, and abstract ideas, close quote, are not patentable. The court advised, however, that these exceptions must be applied cautiously because too broad of a reading would obviously eviscerate patent law at the end of the day. So the court further explained that while laws of nature are not patentable, applications of laws of nature may be patentable. However, adding conventional steps specified at a high level of generality to a law of nature would not transform that abstract idea into patentable subject matter.
And has the Supreme Court articulated a test to distinguish between claims that can get patent eligibility for laws of nature or abstract ideas and claims that impermissibly tie up such laws or ideas such that you can't get a patent?
Yes, yeah. The Alice case in particular from 2014, the Supreme Court set forth a two-part test. First, a court must determine whether or not the patent claim is directed to a law of nature or an abstract idea. If the answer to that is yes, then the court must proceed to a second inquiry during which it must determine whether the claim, apart from any law of nature or abstract idea, considered both individually and as an ordered combination, transforms the nature of the claim, is the wording of the Alice opinion, into a patent eligible application. To so transform the claim, the additional limitation must ensure that in practice, the claim amounts to significantly more than a patent on simply the law of nature itself. Perhaps not surprisingly, since Mayo and Alice, there's been a steady stream of cases in the United States seeking to understand and apply the Alice test and to determine subject matter eligibility, and that trend continued quite prominently in 2019.
Yes, and one of the most important cases in 2019 that's continued to grapple with this question of patentable subject matter was the Federal Circuit case of Athena Diagnostics versus, I believe, Mayo Collaborative Services, right?
Yes, exactly. Well, the panel decision in Athena Diagnostics was actually fairly straightforward, although expansive application of the Mayo-Alice test. In a 2-1 majority opinion by Judge Lurie, the panel affirmed the dismissal of a patent infringement complaint on the grounds that the asserted claims were invalid under Section 101. What was particularly remarkable about the Athena Diagnostics case, however, was not the panel decision, but the fractured denial of a petition for rehearing and rehearing en banc that issued 5 months later.
Got it. First, for background, let's talk about the panel decision itself so folks have the context.
Sure. Athena Diagnostics was the exclusive licensee of a patent covering methods for diagnosing neurological disorders by detecting antibodies to a protein called muscle-specific tyrosine kinase, or MuSK, or MuSK. About 80% of patients with a specific neurological disorder called MG produce certain receptor antibodies, but the named inventors discovered that on those remaining 20% of MG patients, they generated antibodies to a membrane protein called MuSK. Prior to their discovery, no disease had ever been associated with MuSK, And having discovered that association, the inventors disclosed and claimed methods for diagnosing neurological disorders such as MG by detecting antibodies that bind to MuSK.
And what did the Federal Circuit panel decide regarding the patentability of those claims?
Well, applying the two-step Alice analysis, the majority first determined that the claims were directed to a natural law because they recite only the natural law together with standard techniques for observing it. As to the second step, the majority found that the steps of the claims were not drawn to ineligible subject, that the portions of the claims not drawn to ineligible subject matter, whether viewed individually or as an ordered combination, only required standard techniques applied in the standard way. The majority therefore concluded that given the previously unknown correlation, or even given the previously unknown correlation between MuSK antibodies and MG, performing standard techniques in a standard way to observe a newly observed natural law does not provide an inventive concept. The majority therefore found that the asserted claims were patent ineligible under Section 101 over a vigorous dissent from Judge Newman, who was also on that panel.
So then what happened next when Athena Diagnostics filed a petition for rehearing en banc before the entire Federal Circuit?
Well, the petition itself was denied in a one-page per curiam order. But remarkably, that order was also accompanied by over 80 additional pages comprising 8 separate opinions from the 12 judges on the Federal Circuit, variously concurring in or dissenting from the per curiam order. Some of the comments of those separate opinions illustrate just how deeply divided the Federal Circuit remains over the precise parameters of Section 101 in the wake of Mayo and Alice, even 5 years after the second of those 2 opinions, and several of the judges explicitly called on the Supreme Court to revisit the issue or for Congress to intervene.
Can you give us some examples of what these judges are saying?
Sure. Judge Lurie, who wrote the majority panel decision, now joined by Judges Rania and Chen, reiterated that, quote, "Some of us have already expressed our concerns over current precedent, but we are bound by the Supreme Court decision in Mayo," close quote. Judge Hughes, who was joined by Judges Prost and Toronto, concurred in the denial, but observed that, quote, "The multiple concurring and dissenting opinions regarding the denial of en banc rehearing in this case are illustrative of how fraught the issue of Section 101 eligibility, especially as applied to diagnostics patents, is. I, for one, would welcome further explication of eligibility standards in the area of diagnostic patents," close quote. And then Judge Moore, who was joined by Judges O'Malley, Wallach, and Stoll, filed a lengthy dissent from the denial of the petition, commenting that, quote, "Since Mayo, every diagnostic claim to come before this court has been found ineligible. While we believe that such claims should be eligible for patent protection, the majority of this court has definitively concluded that the Supreme Court prevents us from so holding. No need to waste resources with additional en banc requests. Your only hope lies with the Supreme Court or Congress," close quote. So pretty strong language from these judges about their disagreement, but despite these lengthy and disparate opinions from the judges of the Federal Circuit, the Supreme Court denied cert in Athena Diagnostics on January 13th, 2020. So the fracture in the Federal Circuit regarding this issue remains unresolved.
Got it. There were at least 2 other notable Federal Circuit opinions during the 2019 timeframe where the Federal Circuit found patent claims ineligible under Section 101. I think the first of those opinions was by the Chief Judge Prost in the ChargePoint v. SemiConnect case. So what is the background with that case?
Well, the technology at issue in that case pertained to charging stations for electric vehicles. ChargePoint contended that its inventors had invented improved charging stations by creating networked stations. The Federal Circuit analyzed ChargePoint's 8 patent claims separately, but its analysis of Claim 1 is illustrative for our purposes. Applying the first step of Alice, the court found that the claimed invention is nothing more than the abstract idea of communication over a network for interacting with a device applied in the context of electric vehicle charging stations. Turning to the second step of Alice, the court concluded that the claims do nothing to improve how charging stations function and merely add generic networking capabilities to those charging stations and say, apply it. The Supreme Court denied a cert in ChargePoint on January 27th, 2020.
The second notable case from 2019 on Section 101, where the Federal Circuit also found patent claims ineligible, was the American Axle case. And what are the key points about that case?
Well, in that case, in a 2-to-1 decision authored by Judge Dyke, the Federal Circuit panel affirmed the district court's decision that the patent claims asserted by American Axle were patent ineligible under Section 101. The patents at issue in that case generally related to a method for manufacturing driveline propeller shafts with a liner that was designed to attenuate vibrations in the drive assembly. As to the first step of the Alice analysis, the court noted that the district court concluded that the claims were directed to laws of nature, particularly something called Hooke's law, which is a natural law that mathematically relates the mass and or stiffness of an object to the frequency with which the object oscillates or vibrates. The majority concluded that the claim's general instruction to tune the liner amounts to no more than a directive to use one's knowledge of Hooke's law and to engage in ad hoc trial and error of changing the characteristics of the liner until the desired result was achieved. Turning to the second prong of Alice, the majority concluded that the direction to engage in conventional unbounded trial and error process does not make a patent eligible invention. Judge Moore, in dissent, suggested that the majority's decision expanded Section 101 well beyond the statutory gatekeeping function and continued the debate about this issue among the judges of the Federal Circuit, which will continue in 2020 and beyond until the Supreme Court or Congress steps in.
Well, that completes our discussion of the top U.S. patents from 2019, and we're happy to hand it back to Stefano if there are questions or from the audience.
Thank you very much. I think this was extremely interesting, and of course, some of our participants will come from different backgrounds, so it's really interesting in this seminar, but also in the previous 2 seminars that we had, to see the different issues influencing the development of patent law in different jurisdictions. And this was really, really fascinating. So I'll encourage in the meanwhile the participants, if they have any questions, to share them in the chat. But I guess 2 questions that came to my mind. Well, one is about Athena and the Supreme Court denying certiorari in that case. And I was wondering if you think that we are going to see developments in that field in the future, or if this is a message essentially for Congress to deal with this, if there's a need for change in this area. I mean, it seems a strange situation, as you have illustrated quite well, with a Federal Circuit so strongly divided and Supreme Court not weighing in again on this.
Yeah, I do not expect the Supreme Court to weigh in on this anytime soon. They have rejected every entreaty. There, as you might imagine, there's been many cert petitions following the Alice decision, which set forth a formulation that on the surface is rather simple, but in application is very complicated and very nuanced. And obviously the Supreme Court seems to be of the view, look, we've had our say, you guys figure it out. The case that would have been ideal for the Supreme Court to revisit this issue was the Athena case, because you had all of those disparate opinions. So you had 8 different opinions where the judges on the Federal Circuit had set out the various arguments for and against and the flaws with the test. It would have been a perfect opportunity for the Supreme Court to step in, and obviously it declined. So I think this is going to continue to sort of roil the Federal Circuit and the district courts for the foreseeable future. I think the Supreme Court is hoping that as a result of sort of trial and error in various cases, that this will all get sort of straightened out and they won't have to look at it again. I think that's probably overly optimistic.
Fantastic. Thank you very much. We also have a question in the chat. Thinking about the recent Debus decisions. So could Alice, the Alice test be developed to encompass AI-generated products? So what would be the reflections of that line of cases in relation to AI inventions?
Yeah, I don't know that it, I haven't thought about that issue, to be honest, directly, but I don't think that it directly relates to the AI-generated patent issue. I mean, that's a question that is sort of a philosophical debate, I guess, at least in the United States, about whether or not an inventor, whether an artificial intelligence can be deemed to be an inventor. I don't know that, though, that is directly implicated by Alice, because Alice is directed to the subject matter claimed, not who is claiming the subject matter. So in theory, if an AI inventor claims something that was not a law of nature and was not an abstract idea, I don't think it should implicate the Alice issues at all. Somebody more creative might try to argue, I suppose, that only a law of nature or an abstract idea could be invented by artificial intelligence because it lacks the spark of creativity that is the hallmark of patents in the United States, or worldwide, but certainly in the United States. But I don't think I see a direct connection otherwise between Alice and that debate and the AI inventor debate.
Yes, that makes absolute sense. And it would be interesting, you mentioned that definition that the court has given now for a very long time of anything under the sun made by men. It's sort of as an interesting, an interesting point for the future of AI inventions in the US.
No, it is very interesting. And obviously the argument is that AIA is made by humans, so therefore the AI invention is made by humans once removed, so it would fall within patentable subject matter. So far as I know, no court has agreed.
Well, I guess a final sort of questions as we approach the end of our webinar together is, what sort of developments do you expect? What do you think are the areas where we will see developments in 2020? What are your predictions that we can all do before the next roundup?
Well, we touched on a number of them, I think. I think it's, it doesn't take a genius to recognize that the Mayo Alice is going to continue to be at the forefront of patent litigation in the United States. And it's not going to get resolved this year. It's not going to get resolved probably next year, unless and until Congress steps in, which seems unlikely in the current political environment in our country. And the Supreme Court is clearly not inclined to step in. That is going to continue to be a hotbed of precedent and litigation in this country. I think the AIA procedures, the post-issuance procedures that we've been discussing, are going to become less and less important as we move forward. That law was enacted in 2011, so it's, we're now almost 10 years out. It took a long time for certain of the features to get judicial precedent and interpretation. I never would discount the creativity of us litigators to come up with issues going forward, but most of the big issues on those, the AIA post-grant procedures have now been addressed. I think they're still going, except for this question of this ruling about the unconstitutionality of the appointment of the APJs. There will be a petition for cert to the Supreme Court on that issue. If the Supreme Court takes it on, then that will be a big case. I don't sense that there's much, I'm not an expert in this, but my sense from talking with colleagues and others who follow the Supreme Court much more closely than I do there doesn't seem to be much appetite for the Supreme Court to address this question. But we'll see. If they do, that would be a big deal. If not, then I think that issue will recede as well, because the Federal Circuit has already fixed the issue as far as it's concerned.
Okay, fantastic. Thank you very much. I saw another question in the chat. It's again about AI, so I'll ask it briefly because we have touched on it a little bit. But just if you have any thoughts on, rather than patent eligibility of inventions made by AI, but simply on the AI inventor itself. Do you see any possibility? And I mean, of course, the USPTO, for example, recently called for opinions and comments on this very issue. And so something has come out of that as well, but nothing that has changed the law yet. So there has been a change, I think, in the guidance in line with what the UK IPO has done, and clarification on the fact that indeed you can't indicate AI as an inventor as well under US patent law. But other than this, nothing official has come out. There's no particular case law or changes. So what is your sense in this term? Will this be an issue for the future? Is this a known issue? How will it be framed under US patent law?
Yeah, I mean, I think it will become an issue because because of innovations occurring and that it keeps coming to the fore, but perhaps more directly because the U.S. Patent Office has asked for comment on this issue that does suggest that it is going to issue some guidance sometime in the foreseeable future. And if the guidance is to allow AI inventors, that will be a big change in U.S. law, and that will lead to lots of commentary and lots of probably follow-on litigation. If it comes out with the recommendation to not change U.S. law on that front, I suspect this issue will continue to percolate in the district courts over time, but I suspect that will mean that the issue won't be as near term as it would be if the Patent Office issues guidance that is contrary to current U.S. law.
Fantastic. So thank you very much to you. Thank you very much to Shirley as well for this fantastic presentation. And you've also kept fantastically to time. This is the only webinar that we've finished precisely on the hour. So thank you very much on behalf also of all the participants. Thank you on behalf of OUP. And thank you.
Thank you to you, and thanks to each of you for listening. And we have our contact information in the slides if anyone has any follow-up questions they want to email us about.
And as I always say, normally it's Sarah saying this, but if anyone has further questions, one of the ways in which you can address them is by writing on them, doing a bit of research. So we hope that these webinars with some fantastic authors and speakers have also inspired other people in writing about this and doing some research and then sharing with all of us as you've done today. So thank you again very much. Thank you to all the participants, and keep safe.
Thank you all.
Thank you. Thanks, Shirley.
Thank
Bye-bye.
you. Thank you, Shirley. Bye-bye.
Thanks, Stefano.
Thank you.